Hello, my name is Ariella Wagner. I am the founder of SunRay Construction Solutions, and today we have another fabulous webinar. Today's topic is how do I respond to a request for sworn statement of account, and can I send my own? This fabulous webinar is going to be conducted by board-certified construction attorney Alex Barthet. If you have any questions throughout this webinar, there's a wonderful little panel on the right-hand side where you can enter in your questions right there. If you're nervous and you don't want to put your questions in there, you can always send us an email. Without further ado, I'd like to introduce Alex Barthet.
Thanks, Ariella. Everybody, good morning. My name is Alex Barthet. I am a board-certified construction lawyer here in Florida, and today we're going to talk about how do I request a sworn statement of account, and how do I respond to a request for a sworn statement of account, and can I send my own? So let's get started. Let's take a look at the agenda of what we're going to cover today. So first, we're going to talk about what is a sworn statement of account, what happens if you don't respond, how do you respond, and we're going to break that down. We're going to spend quite a bit of time on that. And then we'll talk about the type of documents you can request from the owner once you record a lien on a project. And again, as Ariella mentioned, we'll answer any questions that you have. Use the little chat box on the GoToWebinar function, and then we'll answer all the questions at the end. Please make sure not to include any names of folks or companies in your questions. So let's get to it. What is a request for a sworn statement of account? In short, it's a written request sent to you as the lienor for certain information. This is a document that is prescribed by Florida's lien law that can be sent to you, and it's typically sent for two reasons. One reason is to learn whether or not you've been paid, how much you've been paid, and what you are owed. Another reason, and I would tell you it's as common as the first reason, is in the hopes that you don't respond, because if you don't respond, you will lose your lien rights. So this is what a request for sworn statement of account looks like. And we're going to break down each of the component parts of this request. The key is going to be the warning and the manner in which you respond. So let's break it down. But before we do, let me be very clear about what happens if you don't respond. You will lose your lien rights if you fail to properly and timely respond to a true, and I emphasize true, request for sworn statement of account. And I'm going to talk about what is a true request for sworn statement of account. My guess is that you receive a request for sworn statement of account and you think that you are obligated to respond, and you probably don't have to. At the end, I'm going to tell you probably should anyways, but once we go through this presentation, you'll understand why some of them you can ignore. So how do you respond? So the first thing you need to know is the request that you're getting a true request for sworn statement of account? And the first sign that it is that it has this warning. The warning says, warning, your failure to furnish the requested statement signed under oath within 30 days or the furnishing of a false statement will result in the loss of your lien. So if you receive something that looks like a request for sworn statement of account and it doesn't have this warning, if you don't respond, then you will not lose your lien rights. This warning is required to be given if the other side wants you to respond, the failure of which would cause you to lose your lien rights. Next, it must be sent to you via certified mail to the address listed on your notice to owner. Now, you may get these requests for sworn statement of account via email and not via certified mail. Again, the fact that you receive it via email means that if you don't respond timely or don't respond at all, you will not lose your lien rights because the obligation is on the person sending it to you to send it via certified mail. Now, I would suggest to you that you should always respond even if you get it only via email, and even if it doesn't have the warning, to avoid any issues in the future about whether or not your response was proper. Even if you have a legal right not to respond, it may become an issue in a legal case, and if so, it's just better to say that you responded rather than rely on the fact that they didn't comply with the obligations of the statute. Now, assuming those two things have happened, you have the warning and you received it via certified mail, they're going to ask for 7 very specific pieces of information. So let's take a look at what they are and what you need to provide. They're going to want to know the nature of the labor or services that you performed. This is past tense, and it's only labor or services. So if you are a plumber, you are going to answer that question with plumbing services. If you are a plumbing supply house, you will respond none because you provided no services. Now the next question is the nature of the labor or services to be performed, if any. That is the work that you have yet to do. That's the work in the future. Again, notice it's only labor or services. So if you are a plumber and you have a contract to do all the work in the building and you've done half of it, then the nature of the labor or services to be performed would be plumbing services to complete the project. Next, they want to know the materials you furnished. If all you provide is labor, you would indicate in this section none. If you are a material supply house, you would put in the materials you supplied. So if you are a roofing supply house, you would say roofing materials. If you're a plumbing supply house, you'd say plumbing materials. Next, it wants to know the materials to be furnished, if known. Again, this is the materials that you have yet to provide. So if you have a large order and you've delivered half of it, you would indicate the other half would be, you would indicate in here that the other half needs to be delivered. So you would say plumbing materials to finish the project. Now, if you have no pending orders at this point in time, then you would put none or not applicable. Now, they may decide to order more materials in the future, but if you don't know at the time you respond to the request for sworn statement of account that you have an obligation to furnish those materials, then the answer is none. Next, the amount paid on account to date. That means as of this moment in time when you are responding, how much have you been paid to date on your account? That's going to be $1. The amount due and the amount to become due if known as of the date of this statement. So let's take a look at those last 3 in a little more detail. The amount paid on the account is pretty straightforward. So if you've been paid $100,000 to date on the account, that's what you would put there. If the next one, the amount due, maybe you're owed $50,000, you would put in $50,000 as the amount due. The amount to become due, if known as of the date of this statement, is the amount that you have left to bill on this job. So, excuse me. So if you have a contract and it's a $500,000 contract, and you've done $300,000 worth of the work, then the answer to the last question, the amount to become due, if known, would be the remaining $200,000 left to bill on your contract. If your contract or agreement is such that you only provide services or materials as they are ordered, then and you have no obligation to keep working on this job, you would indicate on that last section, none. So now we know what you need to provide. The question is, how do you provide it? So it needs to be notarized. You need to sign this document before a notary and under oath. That's why it's called a sworn statement of account. It's not just a statement of account, it's a sworn statement, and that means it has to be under oath. You need to send it back to the person requesting it. It has to go back via certified mail, and I would suggest to you that it go back at least one other way, whether that's fax or email. So if the person that requested it sent it to you via certified mail and it has the warning, your response needs to go back via certified mail to them. And again, I would suggest you send it also via fax or email. They need to get it back within 30 days. So you should not delay in responding to requests for sworn statement of account. If you get a request for sworn statement of account, it should go to the top of your to-do list so you get it done right away. You can always provide more information. You just cannot provide less information. So if you want to expound upon the work that you've done or work to do, maybe you have a complicated scope of work, maybe you have some detailed accounting and you feel compelled to provide that, you can do that as long as you provide at least the information I told you that you need to provide under oath. So now we know how to respond to a request for sworn statement of account. We know what a request for sworn statement of account needs to look like. The next question we get is, well, if I have to respond to this request, can I send my own request? And the answer is yes, you can. So if you are a lienor, you can send a written request for certain information to the owner of the project. You can only do that if you want to invoke the penalty, and we'll talk about the penalty, because just like there's a penalty for you if you don't respond, there's a penalty for the owner if they don't respond. You can only get that penalty if you send this sworn statement of account to the owner after you record your lien. Now you can still send this request before you record a lien, but just know that if they don't respond, there's no penalty associated with their failure to respond. So any owner who does not provide the statement of account within 30 days after your demand, or who provides a false or fraudulent statement, is not the prevailing party for the purposes of an award of attorney's fees under the lien statute. That is the penalty that the owner will suffer if they fail to respond to a proper request by you to them. So that means you send them a request, and we'll talk about what it looks like. They fail to respond, they respond late, or the response is not under oath, or it includes false or fraudulent statements. Then their failure to respond means that if you file a lawsuit on your lien and you don't prevail, which means they would be the prevailing party and they would be entitled to legal fees from you, they lose that right to recover their legal fees from you because they didn't timely or properly respond to your request to them. In my opinion, it is a far less significant penalty for the owner than it is for not responding than it is for you as a lienor if you don't respond. But that's what the statute provides for. So let's take a look at what it looks like. So your written demand must include the following warning. Just like they have a warning to you, you need to give a warning to them, and that warning looks like this. Warning: your failure to furnish the requested statement within 30 days or the furnishing of a false statement will result in the loss of your right to recover attorney's fees in any action to enforce the claim of lien of the person requesting the statement. That warning has to be on your request, and your request must include a description of the property, the name of the contractor, and your customer, so if you're the lienor, your customer as set forth in the lienor's notice to owner. So if you are a subcontractor on a project, you will list, you will include the warning. You will also include a description of the property, the name of the contractor, that's the general contractor, and the name of your customer, which is the subcontractor. All of that has to be in your request for the request to the owner to be valid. So what can you get from the owner? You can request the amount of the direct contract under which the lien was recorded. When it says direct contract, that means the contract between the owner and the contractor. So what was the amount of that direct contract? They have to tell you. So if your contract is $500,000, you can request the value of the contract between the owner and the contractor. The dates and amounts paid or to be paid by or on behalf of the owner for all improvements described in the direct contract. So one of the reasons that you may want to request this information is you may record a lien and the contractor says, well, we haven't been paid, and you want to verify that statement. This is one way to do it, by sending this request for sworn statement of account to the owner, because the owner will then have to tell you all the amounts that they've paid or have yet to pay the contractor for all of the improvements on the direct contract. They also have to say what the reasonable estimated cost of completing the direct contract under which the lien was claimed pursuant to the scope of the direct contract. So any additional costs from this point forward, they will list in their response to sworn statement of account. And if known, the actual cost of completion. Now here's what it looks like generally, but you don't have to worry about getting it here. If you go to the lienzone.com, that's our blog, and go to /forms, we have a whole bunch of forms there that you can download in Word format and use, so you don't have to type it up. It's the lienzone.com /forms. So if there are any questions, we'll go ahead and take a look. Ariella, can you see any questions? I don't see any on my chat box here.
So far, I see. Let's see. Hold on one moment for me. There's a great question that was asked. And before I answer that or ask that question, in the SunRay application, if you are one of the SunRay customers, you actually can request and do all of your sworn statement of accounts in the SunRay system. It's actually a form. It will populate the owner. It will populate the services and or materials furnished. So anyone who has any questions on where to locate that in the SunRay system, please feel free to send an email after this webinar, and I'd be happy to walk you through that. And this really great question that was asked is, can the request for sworn statement tool be used for both public and private projects, or are we talking about private projects only on which a lien be placed? Can you cite the statute, please?
Sure. So the request, I assume that the question relates to the request for sworn statement of account to the lienor. So that exists on public and private projects. So if I am a lienor, the owner and contractor on a private job can send me a request for sworn statement of account, and on a public job where it's bonded, the bonded contractor can send me a request for sworn statement of account. The converse, which is the request for sworn statement to the owner as a lienor, only applies to private projects because there are no lien rights on public jobs. And as you recall, I said that this right from a lienor to request information of the owner only exists after you record a lien, and that can only be done on a private job. And you wanted the statute. It's 713.16 is the statute that governs requests for sworn statement of account. Any other questions?
Wonderful. Nope, I do not see any other questions.
Okay, so if you have other questions about the lien law, we wrote a whole book on the lien law. You can go to the lienzone.com /ebook. And if you need help calculating your notice to owner and lien deadlines, you can go to the lienzone.com/calculator, and we'll send you one of these calculators. But if you prefer to use the computer, you can go to the SunRay website, and they have an online calculator right there for you. Our next seminar and webinar is as follows. We have a 3-hour deep dive into liens, bonds, and contracts, all focusing on securing your right to be paid. And that is going to be, the next one is on September 19th from 8 to 11 in Naples. We also have another webinar, which we do every month, which is what is a contractor's final affidavit and when do I need to send one? And that is on September 21st from 9 to 9:20. And you can go to sunraynotice.com/education to sign up for these as well as all future events. Anything
Wonderful.
else, Ariella?
Nope, you did a great job.
Thank you very much. Thank you very much, everybody, for your attention today. I hope you learned something and can put it to good use.
Have a wonderful day.